And we're back. So now we have talked about duties of the person that is the legally authorized individual. We've talked about who that is, in what order, the common law hierarchy. We've talked about your duties as a funeral director and where those duties are established. Now comes the best part, at least I think. The liability for the bill. Okay, who it is at the end of the day that's going to pay us? So let's get started. Clearly, we have a responsibility to our clients. They're usually the ones to sue us. So yeah. But if you want to keep your doors open, you have an obligation to the business. So to your owner, to whoever, you got to collect payment if your business or employer is going to keep their doors open. Don't collect payment, you will be looking for another job. And there are lots of people who have the best intentions who give away their business. And obviously you need to find out who is going to pay for the funeral, ensure that payment is prompt. There are a number of funding sources. So if you remember from the Business Law Review, the estate is usually primarily liable. It's always a party to a funeral expense transaction. The spouse, parent, any person who signs the contract, or even America, okay, the government. So who pays depends greatly on a number of factors to be discussed, and if they are legally become obligated to pay the bill. So the primary obliger, okay, the primary obliger usually is the estate, the real and personal property owned by the deceased. Remember all those words we talked about: devise, legacy, etc., etc. Okay, so the estate is usually the primary obliger. Recall that real property is land and any permanent fixture attached to it. We won't get into the differentiation here about whether the tenant put it on in the course of business or anything. And then the personal, tangible, or intangible property. The estate is always primarily responsible for payment. We've seen they can be placed in a will. We have seen when we were talking about agency, about powers of attorney, that I had mentioned to you that make sure that they just don't have the payment clause, that they actually receive the right of disposition by the durable power of attorney. Remember that. You have to understand that the funeral bill is not a debt against the decedent. The dead guy can't rack up a debt, okay? It's a charge against the estate, the personal and real property, and must, in part, be paid before any other debts are met. This basically means it is a preferential expense. Now, the amount preferential is determined from the state. This comes into the concept of reasonableness of a funeral bill. So states limit the amount of a funeral bill which is given status as a preferred claim on the estate. This does not mean the bill cannot exceed the amount. So, for instance, here in Florida, if you were to go out, buy a nice piece of property, buy yourself a 20-gauge ceiling casket, and have the whole kit and caboodle with the one followed by whatever the next morning. There are some budget places in Florida you can get all of that for probably a little bit less than $12,000. And that's everything: land, casket, embalming. Okay? Realistically, you're probably looking at just about maybe $16,000 to $18,000 at some of the mid-range firms. And in the higher-priced firms, nicer pieces of property, you're probably looking in the mid-20s. And yet, I know in the northeastern United States, especially the major metropolitan areas, New York, Massachusetts, Boston, all of that good stuff, that you're probably looking at like 30 grand for what would be a mid-range funeral here in Florida. So it doesn't mean that you cannot have the $20,000 funeral. It simply means that the preferential amount, the amount that you will guaranteed get paid from the estate if money in the estate exists, is set by the state. And then you're going to get thrown into the residuary. Remember the residuary clause? When everyone gets their gifts and everything's done, all the leftovers get poured into a general fund, and that is where you're going to be raising your hand going, oh, me, trying to get paid for the rest of your bill. So if a will authorizes payment, such a provision is enforceable against the estate, providing the estate has the money. If it ain't got no money, honey, it ain't got the time. Okay? If there is no will, or the will does not include a payment provision, The amount to be charged against the estate in absence of a statutory amount will be limited by the probate to a reasonable amount. And generally, we do not like reasonable because that is subject to personal interpretation. If the court finds that you are unreasonable in your charges, they will only permit payment of a reasonable amount. In determining whether something is reasonable, there are 7 criteria. Now, you can sit there and note card this, okay? And I recommend that you at least do that once. Stuff's probably up on Quizlet. But this is really common sense stuff. Look at what it's saying. What is the size of the estate? How solvent are we able to get the money quickly, okay? What are the rights of the creditors? How much did this person owe that people are going to come looking for payback of the debts? What was the station in life of a decedent? So a $30,000 funeral for a school bus driver is probably not going to be very reasonable. However, if we look at a $30,000 funeral for an attorney general of a state, that might be slightly more reasonable. The religious faith. So depending on the religion, what policies need to be enforced. If they're Catholic, you're probably, and they're devout Catholic, practicing devout Catholics, at least practicing, okay? Fact of the matter is, the religious faith will play into that. Is the visitation reasonable versus not? The person hasn't seen the inside of a church in the last 50 Easters, okay? Chances are you trying to build a bill around their Catholic quote-unquote faith will fail when someone says they ain't seen the inside of a church since they were married 50-something years ago. Fraternal memberships. Back in the day, especially if you have taken your introduction or history of funeral service course, you'll remember that in the 1800s, the processions were led by the fraternal groups, the Masons, the Woodmen, etc. Okay? So how many memberships are there? Those can be pretty prestigious. Local and contemporary custom. If your area pretty much has the visitation, followed by the church service the next day, a court will find it reasonable rather than implement a social stigma if there are the assets in a state. Okay? And the funeral director's knowledge of the financial condition of the deceased. If you know you're not dealing with something large and you did not plan something large, that is reasonable. If you knew the person had a little bit of money and you went and charged a $45,000 funeral, the judge is going to kind of snicker as he only pays you the $6,000 that are statutorily required, for instance, because you should have known better. You're lucky you don't get hit with a fraud, okay, at that point, or undue influence, taking advantage of somebody. Generally, all things equal, the size of the estate versus the funeral is how it is determined reasonableness. If a person has a $1.5 million estate, chances are a $10,000 funeral is going to be reasonable. If a person has a $30,000 estate, chances are a $10,000 funeral will be less reasonable. If the funeral director contracts for some absolutely ridiculous overachieving amount, and you know it's small, the court's not going to pay you. If the funeral director contracts for a large amount and it was intentionally hidden the estate was small, the funeral director was completely unawares, the court may be inclined to pay you more. Okay? So if they told you, oh, he's got a very, very small estate. We're trying to keep the bill as low as possible, and really the lowball price was $10,000 for what they were requesting. And then it turns out that the person was a 8% shareholder in a little company called Samsung. Chances are you're dealing with, a couple million in that estate, $10,000 bucks. Court's probably going to find a way to pay you. So the biggest disadvantage with the whole estate thing is waiting for the damn estate to pay. Okay? It's going to take forever. It can take up to 2 years. And if you look at some of the things that was going on in Texas way back, and remember Anna Nicole Smith, she married that oil magnate. She was like 20-something. He was like 180. That estate took forever. In fact, the son that contested her portion died in the process. It took so long. Well, chances are funeral directors might have had to wait to get paid. Some states permit payment even prior to an executor or executrix, nominated personal rep, administrator, etc., which is nice. That means you get paid before they've even figured out who's going to do what. They just pay done. And realistically, this is why we usually want a third party to execute the contract and give us payment. Okay? Any party that actually pays the bill in the eyes of the court becomes us. They are given the same preferential treatment. So if a son pays the bill, he can present the bill to the estate, and in addition to whatever legacy he is getting, any bequeathment he is getting, he can also receive payment from the estate for the bill. So, funeral expenses of dependents. Now, this is the fun one. This is going to give you some grief. I'm not going to lie. Under the common law, okay, the rule is that a husband and father are primarily liable to pay for expenses of a wife or a dependent child. Remember, common law, early England. Dad was the breadwinner. Mommy stayed at home and had babies, cooked dinner. This is the case regardless of whether the wife or child leaves an estate or whether the husband or father signed the funeral contract. We've already seen there's some, sketchy things going on with the whole right to be there, right not, primary guardian, etc. This takes it even further. No matter what, the husband has to pay. The father of the child has to pay. And the husband or father cannot be repaid from the estate of the wife or the child because he is primary. He's the primary obliger. He is primarily liable. And in this case, the estate is secondary liable. You say, well, Professor Finn, that is some world-class, epic, Godzilla crap. We also have to remember our review of estates, estate policy under common law, that as soon as the wife died, the husband got 100% life estate in any property she owned at any time during their marriage. So why should he get more? He already got everything else, right? Some states have provided exceptions to this, rightfully so. Be aware what your state laws are in regards to practice. That would be important. And generally, we don't even deal with the common law rule regarding that because most of our statutes have pretty much put in that clause. If they sign the contract, they are then responsible for the bill. If the will of a child or wife specifically says the estate is liable, then daddy's off the hook. So if they died testate and the will states that daddy isn't primary liable, the will states that the estate is primary liable for the funeral expenses, then life is good. And if anyone else signs the contract and agrees to pay, daddy, the spouse, is off the hook. Under common law, the duty of the husband is not affected by separation. Liability is not avoided, even if he did not arrange the funeral, attend it, or even if he was unaware of the death. The kid could die, the mom arranges it, and she sends daddy the bill. Daddy eats it under common law, unless mommy signed it. Or the child has a will, which specifically authorizes the estate to pay. And under common law, it wasn't vice versa. There was no duty under common law for the wife to pay for the husband. However, there are some states that have provided exemptions to this or made her liable if the estate doesn't have enough. This was the case in Ohio, where a widow had to repay her stepson because Ohio statute requires her when the estate is insolvent. 1991. You can imagine the people of Walmart experience when the widow found out. And here is a very important concept, okay? A very important concept. The person who requests a funeral director to undertake a funeral does not automatically make themselves liable for the bill unless the law, the statute, says so, okay? And the law will state because it is a relation or because that person expressly or implicitly agrees to become individually liable. Very important concept, because a person can contract with you, yet they are not responsible for the fees unless the law implies it. And now, I know we're dealing with a lot of different concepts. We have consumer protection. We have collection agencies and collection statutes, and intent to defraud and civil actions, all sorts of good stuff. But remember this rule. The person who requests a funeral director to undertake a funeral does not automatically make themselves liable for the expenses unless there is a legal reason because of legal relation to the decedent or the person expressly or implicitly agrees to pay. A widow automatically becomes personally liable in some states unless there is a specific agreement to look to the estate when she requests services. Know what the laws of the state you are going to practice in. And unless a statute specifically defines the rule, the estate is always primary liable. There will be exceptions. We've seen with a child under common law, no statute, then the husband/father is responsible for the expenses of the wife or the child, unless, remember the criteria, right? Unless the will states that it is primary liable or someone agrees to pay the bill, then daddy's off the hook. But unless the statute specifically says something otherwise, the rule is the estate will be primarily liable, unless we bump into the exceptions. But this changes immediately when any person agrees orally in writing to make themselves liable to pay the expense. If someone expresses this, then the funeral director should make them execute a written contract. You can bring that to court for satisfaction. Having a written contract signed by a third party is always a good idea in the event the estate cannot satisfy the obligation. Usually, this is an important concept, usually whoever is in charge of the estate, executor, administrator, nominated personal representative, whatever, okay, is not appointed until the funeral is done, so liability for them is usually a non-issue. However, in the event someone in that capacity does engage the funeral home, it happens rather quickly, there's no dispute, they rush through court, they may be obligated to pay personally unless it was stipulated that the estate will pay, or the funeral director was looking to the estate for primary payment. Okay? Obviously, if an executor does pay for a funeral, they're subject to reimbursement for the reasonable expense. The big thing here is when they are signing. You remember our business law review on agency. If they sign as Bill Smith, and it was not implied that he was executor, it was not implied that he was the administrator or representative, it was never discussed. Bill Smith simply thought in his head that that's what it meant. Bill Smith is going to be held liable. But if he signs Bill Smith, administrator, he's acting in his capacity of that position, which makes the estate, not him personally. Watch for things like that. Remember the whole will thing with the gift to a spouse after divorce. Usually it's done, it's poof, it's gone. But if you list your ex-spouse's name only, a judge can infer that you wanted the gift to go to that individual outside of the marital situation because she was not referred to as a spouse. She was referred to by her name, and that is an important distinction. So remember, 1991, the widow found out that she owed her stepson some money. Well, this is it. A son signed a contract without stipulating he was signing as the executor of the estate, became liable for the bill. You can imagine he was not happy about that. So what did he do? He found out that under the statute that the widow was primarily liable, went after her for payment, which made his stepmother intensely happy. When an executor is vested by a will, a durable power of attorney is vested by the POA paperwork, the advance directive, with authority to pay for a funeral, the exercise of discretion will not typically be reviewed by the court in absence of showing that whoever this person is really acted outside of common sense and good taste. Okay? So that says arbitrarily and improperly determine the amount to be expenses for funeral expenses, which means they really bought way too much and they should have in an attempt to do whatever shady thing they wanted to do. Remember agency. When a state or public official orders a funeral by a public official in the performance of their duties, the state or its subdivisions may be rendered liable to the funeral director for the funeral. So in my professional practice, this came into play a couple of times. A retired priest of a diocese, I think it was Michigan, passed away. And I was contacted by my diocese, the Diocese of St. Petersburg, to arrange for embalming, transportation to the home diocese, etc. And I was given the name of a human resources contact in the receiving diocese. And I contacted them, and the person signed the contract. Dang right I got him to sign a statement of goods. I don't care if it is the church. They signed as a human resources representative. Does that mean that that individual, we'll say for the sake of argument her name was Anne, because I don't remember what it was. So that happens when you get old. You forget stuff. Anne. Does that make Anne responsible for the bill personally? Let that percolate for a second. If your answer is no, you're right. Anne herself is not responsible. The Human Resources Department, or more appropriately the diocese of whatever it was, is responsible for paying my bill, and I have an action against them. They paid the bill promptly. Ensure that the state or one of its agents, one of its subdivisions, signs the contract, accepts the responsibility. Just don't do it because it feels good. Okay? Otherwise, you should be doing it under the concept that you're doing it just for the PR and not for payment. State and local governments may be responsible by law for the full or partial payment of indigent funerals. Know what the process is for indigents in your area. In some jurisdictions, the funeral homes eat it. That is a cost of doing business. If an indigent family comes in, there is no assets, the person is completely poor, then the funeral home just works it in and eats the expense. In some areas, there are contracts that are bid upon by county, by their Board of Commissioners. In some areas, there is a program in place where the state does everything. So just know what it is, and you'll be fine. Folks, thanks for your attention, and we will see you next time.